Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. This video will briefly discuss the K-1 visa, or more specifically the I-134 Affidavit of Support as it pertains to the K-1 visa. So what is this document we're talking about? The Affidavit of Support is essentially a document that proves that the American citizen petitioner who is petitioning for K-1 visa benefits for their Thai fiancé can in fact support that individual in the United States for the 90-day period in which the visa will ultimately be issued. There's also sort of another, for lack of a better term, sort of another broader analysis that's also conducted with respect to the K-1. The K-1 is considered what's called a dual intent visa. What that means is the K-1 visa holder may maintain both non-immigrant and immigrant intent simultaneously. And as a result of that, the consular officer is going to take a fairly broad approach when adjudicating an I-134 Affidavit of Support, as they're not only looking at sort of the four corners of this 90-day period of time that individual is going to be in the United States, they're also looking at presumptively that person is going to go ahead and file for what's called adjustment of status, or an I-485 adjustment of status. There's another video on this channel with respect to I-485 adjustment of status. Basically what it means is the K-1 visa holder has come to the United States, they've gone ahead and married their American citizen fiancé, and they've gone ahead and applied for adjustment of status to lawful permanent residence. They've sort of normalized status, and they're now going to be an immigrant visa holder, a lawful permanent resident. So again, the analysis with respect to the I-134 is not only going to be looking at the actual 90 days in question, but more broadly, can this individual also basically act as the sole sponsor for that underlying fiance while that couple is in the United States. So they're sort of looking not just at the 90 days, but also the presumption that the individual going to the United States is really going to stay there, in an ultimate I-864, because in the adjustment process, an I-864, which is a different document, very similar, but more broader obligations involved, is going to be involved with the adjustment of status. So the consular officer is kind of looking at this situation in a kind of a bifurcated way, sort of from two perspectives simultaneously. It doesn't have as high, the I-134 does not have as high of an obligation attached to it as, say, the I-864's obligation, or as I should say, as binding. It's not quite as obligatory, but for all intents and purposes, it really is. And the only way in which that one could escape or could avoid any further obligation under an I-134 is two ways. I guess the fiance could come to the United States, adjust status, and ultimately naturalize, thereby extinguishing the obligations created under the I-134, or that individual could come to the United States, not stay past the 90-day period, and simply leave. That, I guess, would go ahead and alleviate or extinguish the I-134 obligations. Some things to think about with respect to the I-134 Affidavit of Support is that the I-134 Affidavit of Support requires the individual who's filling out the affidavit, essentially the American citizen petitioner, it requires that they beat 125% of the federal poverty guidelines in income on their 1040, basically, in income, true income, and they're going to use one's personal income taxes to go ahead and ascertain whether or not that income threshold is met. It should also be noted that in the 48 contiguous United States, that 125% is a certain number. In Alaska and Hawaii, that 125% is going to be a different number, pursuant to the Department of Housing, I believe it's HHS, Housing and Human Services, Health and Human Services. So that number is slightly different depending on where one lives in the United States. So it's going to be a little bit higher in Alaska and Hawaii. The other thing to keep in mind with the I-134 as opposed to the I-864 is joint sponsors are not allowed under the I-134 Affidavit of Support. At one time, I did see the occasional officer using some discretion to allow joint sponsorship under the I-134, basically under the presumption that Well, if they need a joint sponsor now, they're going to need a joint sponsor later under the I-134 joint sponsorship rules. It's been my experience over the past number of years that's just gone. That was sort of an old, sort of anachronistic kind of discretion that was sometimes utilized. Now, the K-1 in a lot of ways with respect to the affidavit of support is a bit more restrictive compared to when dealing with an immigrant visa because there are no joint sponsors allowed under the K-1. So, as I'll get into in the other video on this channel with respect to the I-164, which does allow joint sponsorship, the I-134 does not allow joint sponsorship, and that can create some issues. It should be noted that where one falls deficient with respect to their income, as far as the affidavit of support goes, one can make up for the deficiency by showing assets. However, in order to make up for a deficiency, the asset has to have a value or a set amount, like for example, a bank account, just liquid cash. The assets have to be 5 times the deficiency in income. So for example, if one falls $1,000 under the threshold for the affidavit of support, one needs to show $5,000 in, say, cash or assets to offset that, that deficiency. And finally, it should be noted that with respect to any deficiency calculation and with respect to how it's calculated, the consular officers have an intense amount of discretion with respect to that matter. So simply, saying, look, my car is worth this amount, the consular officer may not necessarily agree with that assessment, may want to see more information, may want to see more documentation with respect to one's assets. So it should be noted that assets can be used, but consular officers have a pretty large amount of discretion when looking at deficiencies of income and using assets to offset. Another thing to keep in mind, again, consular discretion is rather absolute. There are cases on this. I will do another video regarding what's called the doctrine of consular absolutism specifically and how that interacts with this overall process. But it should be noted that the consular officers basically have unfettered discretion. So if one falls just $1 over the income threshold per their tax return and believes that they're just going to sail right through the vetting process, do not make that assumption. The consular officers have discretion, and under those circumstances, more documentation may be necessary, delays may be ensued, or a denial could happen based on a finding that there's insufficient documentation to prove that the petitioner can support the beneficiary in the United States.